Hi, this is Lacey. Good morning to those on the West Coast. Good afternoon to those on the East Coast. You may notice that I'm singing with the bass section today. My apologies to everyone. I'm a little bit under the weather. Just goes to show 3 weeks in Washington, D.C. will weaken the immune system. The good news is that the webinar format pretty much ensures that those of you listening in will remain safe. My poor producer, Irene, who's sitting to my right, unfortunately, will have to rely on Purell and good fortune. Let me go ahead and jump into the housekeeping. Let's see. So you're listening into Bar Defense Rule 2017-18 Negotiated Rulemaking. This is a debriefing webinar. It's the third in our series of 3 where we're reporting back on the Bar Defense Negotiated Rulemakings that have been occurring. The program is continuing legal education certified, so if you're an attorney out there and you're looking to pick up CLE, you should have an opportunity to do so. Certificates will be sent in the days following the webinar. Please remember that for CLE credit, you must log in with the same email address you used to register for the webinar. This login is proof of attendance and supports our awarding of CLE to you. If you need to leave the webinar, you should log out and then log back in when you return. If you are seeking CLE credit, you'll also need to verify your attendance. During the webinar, I'll put up 3 top secret code words. You should write them down because you will need that information and you'll need to provide it on the verification form included with your login instructions. Also, if you want to, there's a theme today to our 3 secret words. The first person who emails me the theme correctly, I'll send them a box of Thompson Coburn chocolate. All CLE questions should go to, well, you can send those to me or to Irene. The webinar is timed to last approximately 90 minutes today. I'll respond to questions at the end of the webinar. You can ask a question at any time. In order to do so, just open the chat box on the screen by clicking on the chat bubble in the top right-hand section. The webinar is being recorded and will be available, like all our webinars, free and on demand within approximately 10 days on our TCLE website. It takes a little time for us to do the Q&A. If for some reason you can't locate the recorded webinar after that time, please don't hesitate to reach out to us. Also, please remember, if you're listening to this at some time after the original air date, it's possible that things have changed immaterially. And as we'll discuss today, this regulatory process, this rulemaking is ongoing, and there are big steps coming throughout the rest of this year. So if you're listening to this 6 months or 8 months from now, there's probably quite a bit that's happened in the time in between. Finally, an electronic survey form will be sent following the webinar, and we do deeply appreciate folks taking the time to fill in the form. We try to learn from those comments, and just by way of example, a couple of 3 people were kind enough to suggest last time around that we not spend quite as much time recapping some of the introductory information at the beginning, and so we've done that. We've tightened up here. There will still be a little bit of setup, but we've removed some slides and are going to make sure to get to the meat of the presentation more quickly today. So sincerely, I appreciate the feedback. Try to make these as good as we can and always try to learn each webinar to the next. So most folks here, I think, hopefully, I've looked at the attendee list, probably know who I am. I'm a partner in the higher education practice at Thompson Coburn, Lacey, and our higher ed practice does a number of different things. I've got up here on the screen. I've highlighted a few: regulatory counsel, post-secondary transactions. We do a lot of post-secondary litigation. Something that's not on the screen that I'll just highlight here because it's apropos, we also help folks file comments in response to proposed regulations. We did quite a bit of that after the 2016 version of these regulations were introduced. And if you're listening today and after the Bar Defense proposed rules come down the pipe, you think you might like some help filing comments, that's something we'd be delighted to help you with. My prior experience, I've been in-house, and I've also been in the law firm environment for many years, always working with institutions of higher ed. And the reason we're so involved in this process is because I was one of the negotiated rulemakers, in this case representing general counsels, attorneys and compliance officers from institutions of higher ed at the table during the negotiations. And so a big function of these webinars is not just to get folks out there up to speed, but also to really report back to that constituency. Here's the presentation outline for today. The stuff in red is the heart of the order. So for my commitment to you at the outset here, I'm going to get through these first 3 sections briskly so that we can really spend the majority of our time on BDR3, or the 3rd round of the rulemaking, and sort of where things have come out at the end of the rulemaking. I do, though, want to spend just a few minutes, because there may be a few folks who don't remember or who've not been exposed to this or are just catching this last webinar, to set up what we're talking about. So the borrower defense rule, right, really got its genesis in 1993 when Congress created the direct loan program, and at that point in time, they directed the Department of Education to specify in regulation which acts or omissions of an institution of higher ed a borrower could assert as a defense to repayment of their loan. So in other words, if a borrower took out a loan, and let's say they owed, $40,000 and they graduated, they said, well, wait a minute, my institution did X or Y, they could assert that to the department as a basis for not having to pay back that loan money. The next year, the department laid out a process for adjudicating borrower defense claims. So if someone were to bring that type of defense or make that kind of assertion, this is the process the department would use to resolve it. It's still worth putting this up here because despite the fact that we've had 2 considerable rounds of negotiated rulemaking, and there's more going to this story that's about to unfold, this remains the process more or less that is in place with a few recent augmentations from the department. Essentially, the department right now would initiate a direct loan collection proceeding, or someone could just file an application, and the borrower would assert the defense. They would consider the defense and determine whether to forgive all or a portion of the money that's owed. And then the department right now has 3 years to turn around and try to recover any amounts discharged from the institution that committed the act or omission. And that, of course, is why this is also material to institutions. It's not just a matter of discharging the loans, but for institutions, it's a matter of potentially having to pay back the amounts that were discharged. The department has suggested that a borrower defense could include, and this is the standard right now, any act or omission of the school attended by the student that would give rise to a cause of action against the school under applicable state law. So what a borrower has to say is, my school did something that would be in violation of a state law. And that is still the standard right now, and the reason that's relevant is because it means that the department, when they're adjudicating all the claims that are out there at the moment, is having to figure out which state laws they think would apply and interpret those state laws. That's a cumbersome process, administratively very challenging, and one of the reasons the department was so interested in coming up with a new and revised process. The other thing I'll note is that in 1995, there was some guidance where the department said, well, it doesn't have to, in addition to giving rise to a cause of action under state law, I mean, it also, whatever that cause of action is, it has to relate either to the loan or the provision of educational services. So, for example, a student couldn't just bring a tort claim and say, hey, something happened while I was at the school, or the school did something, and it was a personal injury. I had a slip and fall on the campus, and so I should get to discharge my loans. The department did put a little bit of a box around the type of assertions that could be made. All of this is relevant because these concepts were very much in play during our negotiations, and you'll see later on are sort of the key concepts in a different version that are still being debated. So prior to 2015, the department had received only 5 borrower defense claims. You'll see in some places I call it a BD claim, and others a DTR, a defense to repayment claim. That's the same thing, and my apologies for the lack of consistency there. But the key point is, prior to 2015, virtually no one had ever actually attempted to assert a borrower defense. Then there were a couple of very large, or one in particular large school closing, and then subsequently another one, Corinthian and ITT, which folks are probably familiar with, such that by June 24, 2016, there were north of 26,000 claims that had been filed, with some very large dollar amounts being discharged or potentially being discharged. Today, that continues to be the case, that we're still seeing a lot of borrower defense activity, which of course, again, is the impetus for these rulemakings, is because the department really needs an updated and more efficient process for managing these claims. During the negotiations, the department provided us updated numbers, and I wanted to provide those. I thought folks would find these very interesting. I have not seen these really put out there publicly. They may be, and I may have missed it, but I wanted to put them in my slides so you could see them. What's interesting is you can see, so they told us, and this was information we got in January, but it was current as of November 2017. They indicated there were about 120,000 outstanding claims with about $2.5 billion on the line, potentially. What's really interesting, I mean, I don't want to make too much of this, but if you look, there are a pretty substantial number of claims involving public and private nonprofit institutions combined, or really private nonprofit institutions. And most of the discussion around bar defense tends to focus primarily on the for-profit side of the house. But what this shows is you do have a pretty substantial number of claims that have been filed to date and some serious dollar amounts in play in the particularly private nonprofit sector. Just running some numbers here based on that prior data. So of total claims, you got 43% nonprofit and about 57% proprietary. And of the total loan balance is 36% nonprofit and about 64% proprietary. So not nearly the one-sided distribution that sometimes is discussed. And I think we did see early on in 15 and 16 in the first part of 17. The department suggested in the information they provided to the negotiators that when listing at the publicly traded corporation or institutional level, which I think just means when you sort of say, when you look at that highest level, there are over 1,500 schools associated with the claims. But, and this is the last statistic that continues to be, has been and continues to be the case, 95% of these claims are related to a very small number of schools. So while there is a pretty interesting distribution now starting to develop between nonprofits and for-profits, really what I take away from that is we've got a pretty small number of schools. They did not list the schools when they provided this data, but of those 15 schools, what that tells us is 1 or 2 or 3 or 4 of those must be private nonprofits. I don't know what types of schools we're talking about. That data was not provided either, at least not the most current version of the data. But my takeaway from this is, you know, the landscape is changing a little bit from what it looked like originally, and certainly the fact that you pay taxes or don't pay taxes or are organized in a particular way does not make you immune to bar defense claims. Here's your first secret word. It's booter, B-O-O-T-E-R, booter. So let's just talk a little bit about the BDR2 rulemaking. In October 2015, the department, understanding it had a problem with all of these claims being filed, announced that it was going to create a new rule, and I'm referring to this as BDR2, understanding that the very first version from the mid-90s was BDR1. So they launched a negotiated rulemaking. The purpose of negotiated rulemaking is a process the department uses where it brings together various representatives, sits them around a table, and tries to hash out a rule, and it's done through a series of meetings during which the negotiators that it's tapped to come in and work with them try to achieve consensus. In other words, everybody tries to agree by the end of the period to a particular rule. If consensus is achieved, the department typically pledges to use the rule that the folks came up with. If consensus is not achieved, then the department is free to go on and develop a rule as it sees fit, and it'll issue a notice of proposed rulemaking, so that proposed rule will get out there and folks will have a chance to comment, and then they'll issue the final rule. In 2015, this was the sort of the schedule of topics that were thrown out, bar defense framework, so this process remained the headliner, but there were other sort of related issues that the department pulled into the rulemaking, including financial responsibility triggers, so, you know, things that might occur that they feel like would signal financial risk for an institution and the consequences of a school experiencing one of those events. Arbitration agreements, the department in the last round of BDR2 took action to try to forbid institutions or prohibit institutions participating in Title IV from using pre-dispute arbitration agreements or class action waivers. And then there were also modifications to the closed school discharge provisions, false certification discharge provisions, a new definition of misrepresentation, and a repayment rate concept that just applied to proprietary schools. Consensus was not achieved. So this is the BDR2 rulemaking that occurred in 2017, wrapped up in early 2017. I'm sorry, in 2016, and they did not come to agreement, meaning the negotiators around the table. After publishing proposed regulations and receiving comments through the summer of 16, the department promulgated a new rule November 1st, 2016, and that was set to become effective July 1 of 2017. Also, on January 9th, 2017, one day before the inauguration and the change of administration, the department issued supplementary procedures governing recovery action. So what I mean by that is there was a supplemental rule that was promulgated by the department, which became effective immediately and dictated the process by which the department would go about seeking to recover monies that had already been discharged from an institution and all the procedural rights and obligations of an institution in that process. And again, I want to highlight that that rule became effective immediately on January 19, 2017, and continues to be effective today. All right, so that brings us to BDR 3, and let's first talk about the big picture, and then we'll really get into the meat of things, and I'm going to take just a quick drink of water. So on June 16, 2017, the other side of the inauguration, the new department announced that it was going to delay BDR 2, and then it was going to initiate a new rulemaking. In other words, to totally overhaul and come up with a new rule, which it did, and there was some subsequent activity, and most recently the department has taken the position as a consequence of litigation and other things that BDR 2 is going to remain suspended until July 1, 2019, which is effectively when the replacement rule would go into place. So this administration has essentially signaled that they do not intend to enforce the 2016 version of the rule. At the outset of Session 1, the department made this very clear, in fact, when it said that negotiators are to ignore the 2016 rule entirely and start from scratch. The recovery action regulations, however, the department acknowledged remain in place. So that's that little set of January 2017 procedural rules that were promulgated. And of course, during the negotiations, as a practical matter, the 2016 regulations were not excluded from conversation. I mean, there would be no effective way to do that. But also, everyone in the room was aware of those regulations. So there was discussion and reference to them. But the department's point was, we're not rewriting or revising what we did in 2016. We're basically ignoring it, and we're starting again from scratch. They put a similar suite of topics on the table. So once again, the headliner was the bar defense framework, process for managing bar defense claims and discharging those loans if appropriate. But once again, the department wanted to talk about financial responsibility, administrative capability. They did not propose in this round to actually do away with pre-dispute arbitration agreements and class action waivers, but they wanted to put disclosure requirements around the use of those types of provisions. And once again, there were modifications proposed to the closed school discharge regs, false certification. There were a couple of very specific technical issues that related to guarantee agency collection fees and subsidized usage periods that did flow from bar defense considerations. So in other words, if a borrower asserts a bar defense, what do you do about collection of fees and managing their interest that might otherwise be accruing during that period? So that's sort of technical revisions. The other thing the department did here was establish, which was a little unorthodox, a financial responsibility subcommittee, the purpose of which was largely to conform the composite score language in the regulations to changes that were made by FASB, the accounting rules, in other words, in recent years. And there were a couple of really important concepts that came up in the context of that piece of the negotiations, and I'll mention those too. So, here's your second secret word. We got to it quickly. Crippler. By the way, no Googling. You can't put these secret words into Google. Okay, that's cheating. So the second secret word is crippler. I want to talk first then about the draft federal standard. This was essentially the framework the department led with. And by the way, I'm going to be talking a little bit about changes that occurred between the second round of negotiations and the third. But my goal here is not to try to walk you through how things changed. It's more to talk about, you know, sort of overall where the negotiations ended up and what some of the considerations were now that we've had all three rounds behind us. But the draft framework from the get-go that the department proposed in some ways resembled what we saw in 2016, some ways was very different. Again, the department, there was no collection action required. So the statute really suggests that what the department is supposed to be saying is, if we're collecting from a borrower, the borrower can assert in the context of that collection action a defense, right? And what we've sort of conceded here is that we're not going to require a borrower to actually default on their loans and the department to initiate a recovery action for someone to assert this defense. We're going to let them do it. If they feel like there was an act or omission that qualifies as a borrower defense claim, we're going to let them fill out an application. So the barrier to entry is extremely low, right? You don't have to go into default. There are no fees. You're literally just downloading an application. This, by the way, was one of the principal sort of core arguments that institutions were making throughout the negotiated rulemaking, and one of the justifications for higher standards than what you might see in a state or federal court, right? Our point in part was this process has to be balanced, right? If you're in a court proceeding, that there are mechanisms, fees, other things that act to largely deter frivolous claims, right? Here, none of those mechanisms are in place, and so far as the barrier to entry is very low and someone can just file an application. So it's all the more important that the standards be a little bit higher, right? Because there has to be something that will protect an institution. And it just gives you a sense of sort of from the institutional side some of the arguments that were being made and how all of these things really relate together. It's hard to think about some of these concepts in isolation because it really is a balancing act. So here, it was more or less conceded from the get-go, and the department proposed from the get-go that there would be no collection action required, which again means that it's a low barrier to entry for borrowers. The department also wanted to create a new federal standard, so they wanted to ditch this idea of having to use state laws or review state laws. It's administratively very cumbersome. What's interesting is, right from out of the gate, the representatives of attorney generals, who in this round of negotiated rulemaking were from Texas and Arizona, took issue with the notion of a federal standard and suggested that claims of this sort should be adjudicated in states and pursuant to state standards. Ultimately, I think most of the parties at the table felt like a new federal standard made some sense, but it was a really interesting and certainly valid objection raised, and not totally unsurprising from the folks from Texas and Arizona. I don't know if you can tell I'm smiling through the phone. They were great negotiators, and we learned a lot from them. Actually, I just want to say we really appreciated their participation. So the new federal standards, essentially the department has proposed that there would be two things that would serve as a basis. One is a judgment. So if someone actually gets a judgment in state or federal court, or in a couple other contexts, but a contested final judgment that a school did something wrong that would qualify under some of the things we're going to talk about, you could bring that as a basis for a bar defense claim. You basically show the department that you got that judgment. Setting aside the judgment, though, the department in this case came up with and proposed only one other standard, and that would be misrepresentation. It would be a federal misrepresentation concept. Now, I'm using BDR misrepresentation or bar defense misrepresentation because, as many people on the phone know, there is another definition in the law of misrepresentation that the department uses already. And in fact, during the 2016 negotiations, the department tried to bootstrap that definition and use it in this context. Here, there were a lot of folks at the table, myself included, who felt it was important for the department to come up with a different concept for purposes of adjudicating bar defense claims, and the department seemed to agree with that and proposed that. Definitions of key terms, so they defined not only misrepresentation, but also this notion of financial harm, which is a requisite component of a bar defense claim, in and of itself an important concept. The department, in the context of negotiations, rolled out what I sort of jokingly call the bar defense, which was a list of evidence institutions could provide to rebut BDR claims. Interestingly enough, that disappeared from round 2 to round 3, although it might move to another part of the regs, and we'll talk about that a little bit later. New time limit on asserting a claim. So this was a big point of contention. I'll talk about that in a minute, but basically a statute of limitations on a borrower's discovery or on when a borrower can bring a claim. And the department initially proposed no limitation on recovery actions, although I think that will change in the proposed and ultimately final rule. There was a new individual claim process that the department proposed this time around, which was much better, in my opinion, than what was floated in 2016, not just because it's more fair to institutions, but also because it's just more robust. I think the department was on a very tight timeline in 2016, and at least from a procedural standpoint, didn't quite get the job done. And frankly, they seem to suggest as much in a couple of places when they promulgated the rule November 1 of 2016. Okay, so let's talk about some of the things that were real hot points and in the debate and where we think maybe they might be going. By the way, I want to be very clear, any suggestion I make about where I think the proposed or final rule might land is obviously speculation on my part. It's informed speculation, but it's still clearly speculation. So the department acknowledged in the context of this negotiation, again, they sort of incorporated that 1995 guidance that I referenced earlier, and they said, okay, a bar defense involves an act or omission of the school, but that act or omission needs to relate to a couple of things: the making of a loan or the educational services for which the loan was made. One of my concerns coming out of 2016 and that we raised in the first round of the negotiation was that these are really vague concepts, right? I mean, the making of the loan is fairly defined, but an act or omission relating to the educational services for which the loan was made could be almost anything that an institution does, right? I mean, educational services is an extremely broad concept, and certainly one that, you know, if you're a borrower bringing a claim, you're going to argue that everything virtually relates to the educational services. So one of our objectives going into negotiation was to try to communicate to the department the need to put a little bit of a box around this concept of educational services and to say, look, there are some things that we all feel pretty comfortable should be in the realm or part of what a bar defense claim is all about, and there are some things that should be outside of that box. I was gratified to see that in the very first draft that the department proposed in advance of Session 2, they were explicitly excluding certain types of claims. So, and here I've got the list. HEA violations that are not otherwise BDR claims, right? Personal injury, sexual harassment, civil rights violations, slander, defamation, property damage, educational malpractice, academic disputes, and disciplinary matters. Now, there was some conversation around how to characterize educational malpractice because in some cases, a bar defense, educational malpractice is sort of commonly and historically considered a claim that the school just didn't do a good job providing the education, like you took issue with the quality of the education. And typically the department is saying, well, that type of claim would not be a bar defense claim. Although if you say the reason that the school didn't provide quality education is because they didn't do these, X, Y, and Z things that they said they were going to do. For example, they misrepresented the quality of the lab equipment. Well, that starts to look a little more like a bar defense claim because now you're getting to a misrepresentation. So I think the department in the final rule will see some language that maybe is different from educational malpractice but still gets at this idea and tries to draw a better line. But the other thing the department did in round 3, and this was not in the first draft, but in the draft that preceded round 3, was actually try to introduce a definition of educational services. And just to be clear from my standpoint, anything here is better than nothing, right? Because without any kind of box, I think is extremely broad. There's still a lot that goes inside the box, but there is at least some box now that is being drawn. So what they've said is the provision of educational services relates to, or, a borrower could assert a defense claim regarding provision of educational services related to the program of study for an act or a mission of an institution when such act or mission concerns areas. I have such as in red because it's unclear to me whether that would show up in a final rule. Some of us argue that this list should be exhaustive and not illustrative, right? And the such as turns it into an illustrative list. But even if it does end up an illustrative list, typically the way you would interpret a list like this under law is that anything that you might try to add to the list would still have to look like the stuff that's on the list. So you couldn't come up with something totally different. But you'll see the kind of things. So misrepresentations acts or omissions relating to the nature of the educational program or related resources, the nature of the institution's financial charges, outcomes, eligibility of the educational program for licensure or certification, state agency authorizations or approvals or accreditation, or any other act or omission that's defined in B41. So we'll talk about this later, but B41 in the proposed draft was a list of specific things that the department would consider evidence of misrepresentations. So certainly those were all things that in the department's view would be incorporated here. Again, there's a lot that goes into this box. I understand folks may be looking at it and say, gosh, that's, there's so much that's here. But without this list, remember, all you would have is provision of educational services, which in my view is even broader. So I think ultimately this is a win to have some sort of definition here, and my hope is that the department will land on something that's exhaustive and not illustrative, which is an even better box. Evidentiary standards. So this was a huge point of contention. We debated this pretty hotly right down until the last 30 minutes of the last day. The idea that we're talking about is if you're going to try to demonstrate, if a borrower is going to claim that there was a misrepresentation, right, then, and they provide evidence, their certified statement and then whatever else that they might have, right, and even if the department might have some other evidence available to it, from other claims or something like that, how persuasive does that evidence have to be? Well, how far does that evidence have to go, in other words, to establishing for the department or convincing the department that whatever the act or omission that's claimed actually happened? And that's called an evidentiary standard, right? And you see that all in all types of litigation, and you've probably heard about it before, and different types of claims in federal and state court have different standards. The department initially led with clear and convincing as the standard. So in other words, a borrower would have to provide, or the department would otherwise have to have in its possession evidence that would establish clearly and convincingly that the asserted claim had occurred. Now, the folks representing students, consumer advocates, and others said this is an extraordinarily high standard and it would be very hard for us to satisfy this. There were folks on the institutional side that said, you know, look, we think this is a reasonable standard, not because it would or would not be a reasonable standard in state or federal court if someone were bringing a claim, but because it's a reasonable standard here. And this goes back to the argument I made earlier about this isn't court. You don't have all the barriers to entry that would appear in court, right? You don't have fees, you don't have to have a lawyer, you don't have all the, the diligence and discovery and all those types of things. Here, someone just fills out an application online. At least that's the institutional view, right? I'm sure advocates for the borrowers would feel differently, but our argument was on the institutional side, when you're talking about balancing risks and allocating risk between borrowers and institutions, because there's no barrier to entry, it's important that there be a higher standard, right? So that was the argument. So there was clear disagreement. In an effort, I think, to split the middle, the department came back in session 2 and said, look, we feel like the standard should be higher than preponderance of the evidence, which if you ask, I think, most litigators and others, or if you Google online, you'll see that's sort of the 51% standard, right? That's the, do you think, all things considered, it was more likely than not, right? That's preponderance of the evidence. Clear and convincing is sort of the 75% standard. Sometimes you'll hear beyond a reasonable doubt, you know, that's your 99%, right? Well, we threw around, some people didn't like the idea of using a legal standard at all. They wanted something that was more plain language. I see value in using a legal standard, one, because it gives some sort of context and history for folks to make a determination at the department, maybe keeps a staffer from making a determination that's really apart from the well-established meaning of those phrases. The other thing is, when you get in a recovery action, if you're a school in front of an administrative law judge, having legal standards will be valuable because you're going to be dealing with an ALJ and an attorney representing the Department of Ed in the context of the recovery action, and they will be able to understand legal standards. Some folks felt like it should be a plain language standard because borrowers would have trouble understanding it. You know, I don't know. I mean, I sort of disagree with that. I think that you have people every day who sue other people and go to court over things, and they get lawyers or they get other people to help explain things. And I think the department would help explain these standards too, and information that it put out apart from the actual regulatory language. But at any rate, the point is there was wide disagreement on this. The department came back in session 2 and said, okay, how about substantial weight of the evidence? The problem is that's not a particularly good standard. There is a standard called substantial evidence that applies in certain types of administrative law settings, which really is not a good thing to use here. And so we thought, well, that might even create confusion. Some folks suggested preponderance of the evidence, again, which was that 51%. Some folks just wanted evidence demonstrates. That was, some of the consumer advocates felt like, you know, if the evidence demonstrates at all, we really shouldn't need sort of any kind of heightened evidentiary standard. Of course, the institutional side of things, folks representing institutions tended to disagree with that. Excuse me. I even suggested at one point that we just be literal and say, you know, a standard at the midpoint of preponderance and clear and convincing, because the department articulated, I should note, during the rulemaking that, you know, after reflecting, subsequent to round 1 and reflecting that the department felt its goal was to achieve something between those two. But so, you know, 65%, right, halfway or so between preponderance and clear and convincing. We never got to resolution on this point. It was a real sticking point. The other thing that was interesting is the department added a provision that actually sought to sort of define what the evidentiary standard meant. So remember, when they came back after round 2, they used this language of substantial weight of the evidence. So there was this other piece in the law where they said, and the secretary may find that the substantial weight of the evidence supports the approval of a bar defense claim when the borrower's statement is supported by corroborating evidence in addition to the application attestation provided by the borrower, other parties, or otherwise in the possession of the secretary. So what was interesting was, you know, we're having all this debate over what evidentiary standard should be used, and then the department sort of defined the evidentiary standard away by simply saying, look, you know, whoever the staffer is that's making this decision can essentially find in favor of the borrower as long as the statement is supported by evidence in addition to the signed attestation, which in my mind sort of undermined the use of that legal standard or the evidentiary standard. But one thing is clear, you have to think of them all sort of together, right? So not only did we debate the evidentiary standard, but we also debated at length this piece of it. And you know, the institutional side took the view pretty strongly that at the end of the day, a sworn statement from the borrower cannot in and of itself be deemed sufficient evidence for a borrower defense claim. There's got to be something else, corroborating evidence supporting that signed statement. Because just remember, there's no barrier to entry here. So if someone can just fill out an application and you will discharge $80,000 of loans based on what they said in the statement, then you know you've basically got no standard, right? I mean, all they have to do is allege a claim, and in many cases, particularly as you get further out, institutions may not be able to produce any evidence that would rebut that claim other than their own statement, right? So you know, one of the key points I think on the institutional side was there's got to be something in addition to just the signed statement. It is my speculation, my view, that the department agrees with that, and that what you'll see in the ultimate rule will be a requirement that the signed attestation in and of itself is not sufficient. You know, I've got a line through corroborating because it was, that word was used originally, and then it was at one point sort of dropped out. And I should note, for folks who've never been to a negotiated rulemaking live, I mean, the department literally had this language up on a board, and negotiators would, or on a screen, and negotiators would make suggestions, so then someone managing the computer would put a line through something or delete it or add something back in. And, you know, we didn't always vote on that language, and sometimes we'd move on to completely different concepts. So it's not as if the department would put together complete packages and iterations and give them to us. There was a lot of movement happening in real time, and it wasn't always clear whether the department necessarily agreed with some of that movement or was just allowing it to put up on the screen. I've advocated for continuing to use corroborating. I don't think that it should just be any evidence, but it needs, corroborating indicates that it needs to be evidence that specifically supports the statement. But whether you use it or not, I think that this would still get there, and I think the department feels pretty strongly that you definitely need evidence in addition to the attestation itself, right? So where they'll come out on the evidentiary standard, I mean, they indicated that their view is that it ought to be somewhere between preponderance and clear and convincing, which is not a terrible standard for institutions by any stretch. And they also indicated this idea, which of course we agreed with on the institutional side, that there's got to be something in addition to just the sworn statement. And I think you will see something along those lines as in the proposed rule. The next critical point was this definition of misrepresentation. So you'll see up here on the top of the slide, I've got in parens S2. That is my way of signifying that this was what we got in advance of Session 2 and the language that was debated at Session 2. The institution at which the borrower enrolled acted with an intent to deceive, knowledge of the falsity of a misrepresentation, or reckless disregard for the truth in making a misrepresentation of material fact, opinion, intention, or law upon which the borrower reasonably relied in deciding to obtain direct loan to enroll or continue enrollment in a program at the institution, and which resulted in financial harm. So from an institutional perspective, there are several key ideas here. One is intentionality. Now, I would not call this an intent standard per se, because knowledge of the falsity of a misrepresentation or reckless disregard don't necessarily require intent. But if you look at the legal concept reckless disregard, it's just shy of intent. So you have to show it's higher than ordinary negligence or even gross negligence. It's just shy of intent. Somebody has to really be looking the other way and ignoring something to get there. Knowledge of the falsity of misrepresentation does not require intent, but clearly you would know that you were providing someone with something false. But you've also got materiality in front of fact, opinion, or intention. You've got the requirement that the borrower reasonably relied on the assertion or the representation, and then the borrower has to demonstrate some form of financial harm was incurred. So there are a lot of important concepts here, particularly as compared to, say, the 2016 standard, which some of you may be familiar with. So the department, remember the department, part of its objective was to try to get to consensus. So at times they were listening to the feedback from the parties and attempting to craft language that they thought would be more likely to get to consensus. So when they came back for Session 3, they'd done a couple of things. They'd moved some of these concepts around a little bit, and you'll see that because there are two parts to this now instead of just the one part on the prior slide. But the first thing they did was they said, okay, the institution at which the borrower enrolled had to have made a misrepresentation of material fact, opinion, intention, or law upon which the borrower reasonably relied under the circumstances in deciding to obtain a direct loan, et cetera, that resulted in financial harm. Okay. So they've moved the intent concepts out into the definition of misrepresentation, and I'm going to get to that next. But you'll see here that we still have the materiality concept. They took reasonably out, and they just say borrower relied under the circumstances. You know, I highlighted for them that that didn't really make good sense and that we should continue to include reasonably, so it's unclear to me whether that will be in or out. And by the way, I should also say the department could go back to the drawing board and radically change all of this. That's not the impression I get, but just to be clear, I'm speculating, understanding that the department could do something completely apart from the drafts that we've seen. That is typically, though, not the way it goes. So the financial harm element also is still in play. But importantly, when the department for Section 3 rolled out its definition of misrepresentation, it said a misrepresentation is a statement, act, or omission by an eligible institution to a borrower that is intentionally false or misleading or made with a reckless disregard for the truth, and again relates to enrollment or the provision of educational services. So, and this is a really important point to me, now they took out the knowledge of falsity, but they continue to use intentionally false or made with a reckless disregard for the truth. You know, understand that the consumer advocates from the first day of negotiating argued against an intentionality standard, right? In fact, they wanted this whole concept thrown out. Several people representing borrowers said on multiple different occasions that in their view, even if an institution made a mistake, had no knowledge, and there was no intentionality, if a borrower suffered harm, that they should be able to discharge their loans, which is a mistake standard, right? So it doesn't matter if it's a mistake or not. They should be able to discharge their loan. The department, despite all the negotiation, 11 days, right, across the 3 weeks, and the department at times was willing to propose revisions to the language I showed you earlier, you know, relating to the definition of educational services, or the language relating to the evidentiary standard, and you'll see on the next slide I'm going to talk about in a minute, statute of limitations. They were willing to propose compromises in all of those places, but they never dropped this intentionality concept. In every iteration, every time the department came back and said, we tweak this or we tweak that to see if we can get to compromise, the intentionality and reckless disregard standard always hung in there. Now, there was someone who proposed striking reckless at one point, and that went up on the screen and came back down. But even in the last draft that we got from the department, intentionality and reckless disregard were still there. My impression is that the department has a willingness to think about and maybe move on all the other pieces, but that they are not going to move on this piece, right? Which is certainly positive from an institutional standpoint, because this means that the institutions are not being held responsible for mistakes. They're being held responsible for things that they either did intentionally or should have known better than to have done, right? And then you still have the idea that it has to be material, it had to be relied upon, and there has to have been financial harm. The one side note I will make, though, is the reason that evidentiary standard is so important, and you don't want to compromise too much on that, and the reason that this definition of how much evidence has to be supplied is so important is because, in theory, if the department dropped an evidentiary standard completely and said, okay, an attestation is sufficient, then someone would only need to attest that this misrepresentation, that it was intentional, and they wouldn't need to provide any evidence of intentionality, or the department wouldn't have to have on hand any corroborating evidence, because the attestation would be sufficient. So this standard is really important, and I'm for institutions and risk managers, pleased that the department seems committed to keeping some notion of intentionality or reckless disregard in place, which again I think is very important given the low barrier to entry. That's, you know, again, someone just has to fill out an application. It's not like court, there's no discovery, there's not all the cross-examination, et cetera. It's just filling out an application. But the evidentiary standard remains very important, because if it goes too low, then all someone has to do is allege intentionality, and their statement is considered sufficient evidence to prove, right? So they do all relate, and it is important to keep that evidentiary standard at least at a reasonable level. So the last real sticking point was statute of limitations. And interestingly enough, originally in session 1, there wasn't a lot of conversation around it. It became a sort of a more heated topic as we went on. the consumer advocates a couple of times said, well, we don't think there should ever be a statute of limitations, right? So at least for the life of the loan, a borrower should be able to bring a claim. And a couple of folks said, well, you know, so for infinity, I mean, until they pass away, a borrower should be able to bring a claim if they discover an act or omission on the part of their institution, qualifying act or omission. Several institutions, including the folks represented financial aid officers and some of the nonprofits, pointed out that, you know, the U.S. government, states, and FSA in particular are directing institutions not to keep data and records beyond the point at which they're required to do so under applicable laws, right? And that's because of big-time privacy and security concerns, right? The longer you have data, the more likely it is to be hacked, and it's not good to have a bunch of personally identifiable information in your system for thousands upon thousands of students, right? So there was a tension between this statute of limitations and that directive, and we made the point several times. It's not fair to institutions for the federal government and all these privacy folks and all these state agencies and everyone to be telling us, you know, don't keep these records for cybersecurity reasons more than the prescribed 3 to 4 year time frame, right? A lot of schools have a 5-year time frame by their accreditor, but we'll say outside of that 5 years, you shouldn't keep it beyond that, right? And at the same time, potentially put institutions on the hook for 10, 15, or 20 years after the fact, because at that point, institutions aren't going to have the records. They've ditched those records, and that's what they would need to defend themselves. Also, you just have the general notion of why we have statute of limitations. I mean, philosophically, the further out you get from the act or omission occurring, the less likely it is that either party, the borrower or a school, are going to have good data or good information that they can, and so it diminishes the likelihood of justice being done, right? And as one of the negotiators like to say, you know, we've got 2,000 years of jurisprudence that incorporates the idea of statute of limitations. We shouldn't just ditch that altogether. It makes no sense. You know, I certainly agree with that. So then the question became, what should it be? The department led in session 2 with this idea of 3 years after the date of discovery, or the date at which the claim should reasonably have been discovered. So 3 years seems like a short time frame, but remember, reasonably should have discovered could extend the statute of limitations for a pretty significant period, right? I mean, if a borrower just didn't know or wasn't sophisticated enough to know or was out of the country or whatever, it could be 6 or 7 or 8 years after the fact before they could reasonably have been expected to discover an act or omission. And there was no time limitation on recovery actions. So in other words, the department was saying, look, we're going to limit when borrowers can bring claims, but once a claim's been adjudicated and loans discharged, I mean, we can essentially, you know, at any point in the future, bring a recovery action against institutions. And we said, no, you know, that's really not fair. You have the same statute of limitations, those philosophical reasons for statute of limitations should apply here as well, even if it is the department. And the other thing is, why would the department ever be unable to timely bring an action, right? I mean, the department said we're going to seek to recover on loans that are discharged, and they would know because they're the ones that discharge the loans. So what's the rationale for the department needing sort of an unlimited time frame to bring an action against institutions? So in session 3, they still came back originally with this 3 years. It was proposed instead as an alternative to the 3 years, a hard 5 years from termination or withdrawal or graduation. The reason being there, and this is one of the things I spoke to, was from an administrative standpoint, first of all, it's much easier for the department to determine. The other thing is you don't end up with borrowers and institutions arguing over the 3-year concept and whether or not a matter should reasonably have discovered by a borrower, right? Because I said, look, every time that's going to be a point of contention between a student or borrower and an institution. So this gives borrowers and institutions more clarity as to what the applicable statute of limitations would be, and the department as well, so it's easier to administer. You know, in terms of whether in the particular instance it would be more or less likely that a claim could be brought depends, right, on the particular circumstances. In some cases, 5 years might make it possible for a borrower to bring a claim that they wouldn't have been able to bring under the prior standard, the 3 years or reasonable discovered standard. On the other hand, it also could clip, you know, like I say, someone could go out of the country for 6 years and come back, and under this standard, they would no longer be able to bring a claim. So it just depends. Excuse me. The nice thing is the department also indicated that they would limit themselves to 3 years. Now, you know, I do expect the department, one, they've pledged that they're going to try to recover any amounts discharged, and two, I would expect they'd be able to do it in 3 years. But at least now, from an institution standpoint, You know, if you're talking with your insurance provider or, you know, whoever, your accountants, you know, and you're trying to talk about quantifying risk, you know, you can give them an end date beyond which any bar defense claims that have been adjudicated and discharged, you know the department will no longer bring that claim. So we thought that was a really important concept that got included. The department offered up a list of evidence of misrepresentation. So these were sort of specific examples, and the department said, look, someone could provide, a borrower, I should say, could provide evidence that these particular things occurred, and we would consider that evidence of a misrepresentation. I mean, they did use the language may, so it's not, you know, it's possible you could provide evidence that one of these things occurred, and the department could still conclude under the circumstances that it did not constitute a misrepresentation. But, and of course, there's the financial harm element and whether or not the misrepresentation was of a material fact, circumstance, et cetera. But I think from an institutional risk management standpoint, you would want, should these make it into the final rule, to look specifically at these and understand that these are things the department is really targeting. They all essentially work the same way and relate to the idea that there would be some sort of material difference between a representation about one of these things and the truth, you know, the actual circumstances. So licensure passage rates, employment rates, specialized programmatic or institutional certifications, transferability of credits, employability or earnings, availability or nature of financial assistance, tuition and fee amounts, endorsements or prerequisites, institutional size, location, facilities, training, equipment, or faculty quality. And a lot of folks around the table from the institutions, including the nonprofits, financial aid folks, everyone, had tweaks to some of these things and had various recommendations. There wasn't a lot of movement from what the department had proposed, and it wasn't clear to me where those little tweaks were suggested, which ones may or may not have been adopted. Financial harm. So this was the other concept I mentioned. A borrower does have to establish, among other things, that some type of financial harm was incurred. The department led with sort of a general concept or definition of what financial harm might mean and what it might not mean. Importantly, the department was excluding damages for non-monetary loss like inconvenience, aggravation, emotional distress, pain and suffering, and punitive damages. We went back and forth on opportunity costs. The institutions, one, felt like opportunity costs should be included, and two, and this was a point I made, noted that that concept, I mean, how would the department possibly quantify opportunity costs, right? Someone could just allege, well, I thought I might do this, or I might have thought do that. You know, if it hadn't been for this school, I was going to go to medical school. I mean, how would you know? Whether opportunity costs, I mean, the department led with the idea that opportunity costs should be excluded. So whether or not they were persuaded to exclude it, we shall see. The other thing is the department allowed that financial harm, that essentially an institution could demonstrate that monetary loss was not predominantly due to local, regional, or national economic or labor market conditions. Now, the addition that came along in Session 3 was as demonstrated by evidence before the department. So an institution couldn't just assert that, you know, whatever monetary loss the borrower is claiming was really just reflective of these national economic or labor trends. I mean, you'd have to provide some evidence to that end. The department also gave some specific ideas around, you know, financial harm. I'm not going to go through all of these. I've included them up here, sort of like the specific misrepresentation examples. These were debated, and there were small variations here and there, and comments that were made to try to improve the language or increase clarity. You know, I want to point out to folks, I don't want you to read some of these, and you know, like you might read up here, the fourth box says extended periods of involuntary unemployment. That actually should say periods of involuntary unemployment, not extended periods of involuntary employment. You know, you might look at that and say, well, wait a minute, you know, just because someone wasn't able to get a job, that shouldn't mean that they get to discharge their loans or that you know, and that's true. Remember, these are just examples of financial harm. Just because someone has experienced financial harm does not mean that that financial harm was the result of an act or omission on the part of the institution. So there is a nexus requirement. Remember that evidentiary standard I harken back to, clear and convincing, preponderance, whatever it might end up being. You still have to show that the institution did something intentionally or with reckless disregard, that misrepresentation was material, right, of a material fact, opinion, et cetera, right, and that it was that that intentional or with reckless disregard material misrepresentation that was made, that the borrower relied upon it, and that all of that resulted in this financial harm, right? So if you go to Harvard Law School and you graduate, and Harvard's provided you information about the average income of their graduates, but you decide to go work in a public defender's office and you make $27,000 a year, you've experienced financial harm under one of these definitions, right? Because you're making a lot less than what the institution may have suggested their graduates make. But it doesn't relate to some sort of misrepresentation, and it would not be a basis for a bar defense claim. You know, again, I just want to emphasize you really have to think about all of these things together, and just sometimes it's easy if you get off into one element or another to either become overly concerned or not concerned enough, right? So it's really important to understand how they all work in concert. I think, you know, this is a hard idea, and the department was trying to put some sort of box around financial harm. I think it's very positive for institutions that there is a requirement that financial harm have to be demonstrated in the first place. That didn't even exist in the 2016 rule, right? So now there's a requirement that some form of monetary financial harm has to be demonstrated for someone to bring a claim. And here what we're talking about is, you know, what sort of box are we creating around what would constitute financial harm? All right, the borrower defense, I mentioned earlier that in session 2, the department had proposed this list of certain types of things or evidence that an institution could provide to rebut a borrower defense claim, right? So the department told us when we came back in session 3, and that was debated back and forth. When the department came back for session 3, they said, we've removed that entirely, but we did it as a compromise for keeping intentionality in the definition of misrepresentation. Remember, this goes back to the point I made earlier that it is my view that the department is very committed to that concept of intentionality and is willing to give in other places. Now, one of the things that was suggested in session 2 was that these sort of evidentiary, you know, these things that you could provide to the department, and an example of I have here is evidence showing that an institution provide information to the borrower to correct a misrepresentation prior to the borrower enrolling in the program. Another was sort of a bad actor carve-out, right? So an institution could provide to the department evidence that this was a one-off by a bad actor who was not acting consistent with, you know, policy, et cetera. And the folks representing consumers said, look, why would, if you intentionally did something and you satisfy all the standards that we've got here, and there was actual financial harm to a borrower, why would the borrower not get to discharge their loans even if it was a bad actor? And which is not an unreasonable point, right? One of the negotiators said, well, maybe where this should be is in subpart G in the recovery action section. And what we should be saying is these aren't defenses to, these aren't things that would defeat the claim, but they are reasons that the department should not get to recover from an institution. So in other words, yeah, something happened. Someone at our school, a bad actor, lied to a student, and they suffered harm, right? And all the elements of the claim were satisfied. So they would get their loans discharged. But if the institution can demonstrate that this was a bad actor, then the institution shouldn't be on the hook for that, right? The department's reluctance, as you can imagine, to adopt that kind of approach is that it exposes the taxpayer. Because they're discharging loans under one standard, but then they're saying, you know, we're not going to recover from the institution on the other. That having been said, I think the department was somewhat responsive to that. What I can tell you is that I specifically made the point in round 3, as did several other people, that, you know, if the department was going to remove this as a trade-off for keeping intentionality, if that was their view, then we would suggest strongly that it show back up in subpart G, so that institutions could still assert these concepts as a defense against recovery, right? And we suggested that that would be very good public policy because you want institutions to correct misrepresentations. You want them to report bad actors, so you're creating an incentive for them to do so. You know, I didn't have a really good read on where the department came out on all this. Again, I think the department is committed to an intentionality standard and is going to be willing to give on some of these other places so that it can feel comfortable that the intentionality standard is justified. All right, so let's talk about the claims process. I really just have one. I'm just going to walk sort of through this. There was a lot of conversation around this. My impression, though, from the get-go was, one, that we had a much better process, and the department was very open to a much better process. I mean, even the very first draft was careful to provide equal rights to everybody, to make sure that institutions had prescribed timeframes and clear defined opportunities to provide evidence, et cetera. So this administration seemed very committed to making sure that this process treated both parties more or less in a fair way, right? Whereas the first, at least suggested process in 2016, I mean, there were many parts in the process where schools had no notice or didn't get any evidence or had no opportunity to sound off, et cetera. So that's not been the case here. The other positive thing is there wasn't a lot of push. I mean, both sides seem to be pretty comfortable, both sides meaning folks representing institutions, folks representing consumer advocates and borrowers, and frankly, you know, the other folks in the middle, the AGs and the accreditors, everyone seemed to be pretty comfortable with the idea that if the process treated both sides the same way and gave them a fair shake, that that was okay, right? And you know, institutions would have their day, they would have prescribed, you know, time frames in which they could respond, all those types of things. So my feeling was that, you know, this got closer to consensus than the first section that I just went through, which was issue paper 1. This was sort of issue paper 2, the process. The process that we more or less ended up with or got close to was that, you know, again, a borrower could just submit an application, then the department would immediately grant forbearance or suspend collection activity. Then, and I thought this was really positive, and this was an add-on in my mind as compared to 2016, the department would qualify the claim. So they have this sort of initial step before they even involve institutions, where they just look at the claim itself and see if it, even on its face, has asserted all of the requisite elements. One of the things the department noted that has been happening quite a bit is and this won't surprise the schools on the line because I know most schools have received at least a complaint or two over the years where it's very unclear what's being asserted, right? And the department, you know, verified that during the negotiations, they've received lots and lots of claims, and in many cases, it's not filled out, it's not complete, it doesn't state all the requisite elements for a borrower defense claim. So they've included this initial step basically to say, look, I mean, we're going to qualify the claim, and if it doesn't even get there, we're going to let the borrower know. Borrower might go away, borrower might just fill out a new application and get it right, but it's important that the department included this qualifying step. If qualified, the department will notify the borrower in school, this is what was proposed close to the end of the session 3, notify the borrower in the school, provide the school a copy of the application and evidence, and inform the parties of the option for a 60-day voluntary resolution period. Okay, so in my mind, the most important issue we were debating in the process piece is this notion of a voluntary resolution period. We talked about this at length. By the way, I want to give credit to Chris DeLuca. Some of you guys may know Chris DeLuca, who was the one, I believe, who introduced this concept. And in session 2, there was general agreement among everybody at the table, including the borrower's representatives, that if it was done correctly, that this could be a very positive thing. And the idea was, you know, one of their concerns, the consumer advocates' concerns, was that borrowers often are unsophisticated. They don't have anyone sort of not necessarily advocating, but just explaining to them what their rights are and how these processes work. You know, on the institutional side, we said, look, for good actors, I mean, we're not here to defend bad actors that are predatory and you know, lying to students. Well, we were there to defend and to negotiate on the behalf of good actors that may have done nothing wrong, but someone filed a claim and they want an opportunity to try to work with that person in advance of having to go through an official claim process and deal with the economic and reputational costs of all of that. We said, look, a lot of good actors, schools that we know of, would really appreciate a chance to work with the borrower and see if they could just resolve this up front, right? So we said both sides seem to agree that if the department would install a voluntary claim resolution process in advance of the official adjudication, that could be very positive. And the idea was, you know, and Chris DeLuca suggested and highlighted, which is true, that the Office of Civil Rights has a concept like this, early claim resolution, right? And you essentially get someone who acts somewhat in the capacity of a mediator, and they help with the exchange of information, and they explain to the parties what's going on, sort of in their rights and obligations, and then they help encourage and facilitate them trying to come to a resolution informally. We said, look, we think that would work here. Now, the department's initial objection was cost. And one of the points I made and other people made was, you know, if you don't have an upfront process and it doesn't get resolved informally, and you have to adjudicate it, you're involving a staff member at the department who has to adjudicate the claim anyway.
Then, if you want to recover from a school, it has to go to an administrative law judge. You've assigned an attorney from the U.S. Department of Education, and you have to go through another big process to recover the funds. Wouldn't it be more cost efficient to resolve this informally on the front end for the taxpayer and for the department? I continue to believe that that has got to be self-evident, but in the least, we strongly encourage the department to do that analysis, understanding they may not have had a chance to really run the numbers between sessions 2 and 3. So Chris DeLuca and I actually drafted language at the request of the department and provided it, and we were disappointed that what the department inserted for consideration, and our language was ultimately circulated to all the negotiators, but this concept on the screen is what the department actually floated in the reg that they drafted, which was that the department would place the borrower's claim application in abeyance for 60 days, but that the department would have no role in the resolution process between the borrower and the school, and that if the borrower and the school resolved the borrower defense claim through the resolution process, the borrower would waive any right to further pursue the borrower defense claim. If the borrower and the school did not resolve the borrower defense claim through the resolution process, the department will resume the adjudication. Now, I will say, I still think it is far better to have something like this than nothing for institutions, right? I mean, this means that after the department gets that claim and they've qualified the claim, the first thing they're going to do is they're going to send a notice to everybody and encourage or at least notify them for the opportunity. Now, nothing's forcing a borrower to reach out to you as an institution. The borrower may say, I don't want anything to do with that school, right? And that's their right. But now there's at least a window of opportunity for the school and the borrower to try to negotiate and resolve the issue. And I think this will be very positive for good actors. So my hope is that this will still show up. But you can imagine that the consumer advocates were very unhappy with this, because the whole reason they were interested in this concept is that borrowers would have access to the department and maybe some chance to be educated by the department, and this doesn't afford that. So my expectation is if you're dealing with a borrower that may be working with legal aid or someone like that, you know, they may just tell the borrower not to get involved and to pass, right? And my understanding is if they pass, you know, it's a voluntary process. Both parties have to want to do it. If they pass, it's just going to kick you right into adjudication. That may be something, by the way, that, you know, if the department, I mean, I encourage folks to comment on the proposed rule in general, but that's one piece that I really encourage institutions to look at what the department comes up with and to think about whether or not you think it gets you there. So if whatever may come about in the way of voluntary claim resolution, if that process is not successful, here is the adjudication process that ultimately was put up on the board and discussed. And there were folks who had different opinions about this, but I think you're going to end up with something in this ballpark. Voluntary resolution process would not be successful, so the department would proceed to adjudicate the claim. The school would have 45 days to submit its response. Then the borrower would receive the school's response and have 30 days to reply, right? So you have the initial claim, the claim, and any supporting evidence gets forwarded to the school. The school gets 45 days to respond. Then the school's response is sent to the borrower. Borrower has 30 days to respond. After that, the school has 15 days to respond and provide any additional relevant evidence. So the school actually gets the sort of the last chance. The department reviews the evidence, including departmental records. This is a really important point I want folks to understand. The department is not limiting its review to documentation provided just by the borrower, right? So if there's an AG investigation and the AG in some state provides the department with all its evidence, if there are other claims that have been made by other borrowers asserting the exact same thing, the department could look at, if the department's done its own investigations, all of that could be considered as relevant and corroborating evidence, right? And but this was an important point to accept in some sense for institutions, because it also was the reason that we suggested vehemently that there was no group claim required, because there was an avenue for that stuff to be considered. And it was also why the idea of corroborating evidence did not create an impossibly high standard. You know, a lot of the consumer advocates said, well, wait a minute, if a borrower needs to have something, you know, let's say a school lied to them, and you're saying a borrower has to have something in addition to their signed statement. Well, how many borrowers are going to have, you know, access to paper or something that they can show that the school lied to them? And at some points, there were consumer advocates who said, you know, this is what would have to happen. A borrower would have to have additional evidence, and that would never happen. And one of the points we made was, which is true, is that's not the case. A borrower, the borrower doesn't have to supply sufficient evidence alone to move forward. It just has to be that the secretary the department, when adjudicating the claim, has in its possession sufficient evidence. So corroborating evidence could be 20 other claims that say the same thing, right? So it's not just that you have the borrower's attestation, but you have 20 other borrowers' attestation, right? Again, it could be evidence that the department has pulled together through a program review. It could be an AG complaint, right? And it's important that institutions understand that too. So, you know, while it also was another reason that we consistently argued that the intentionality standard, right, that the evidentiary standard, all those things were justified in being at the level that they were at, right? They are higher standards, and that's because the barrier to entry is low, and the department will have access to a lot of evidence and things that it can consider corroborating claims. And because all of this hangs together and works together, you know, it's important that when some things are lowered, like barrier to entry, that other things are elevated to avoid frivolous claims and give institutions a fair opportunity to defend themselves, right? Okay, so after the department adjudicates, it issues a written decision to the borrower and the school. Believe it or not, the 2016 version did not actually obligate under law the department to provide notice to the institution of the outcome. And then finally, in accordance with the statute of limitations we discussed earlier, the department can initiate a recovery action against the school. So there is some possibility that even if loans were discharged, that the department would not look to recover those amounts. They have indicated their intent to recover any amounts discharged, but there is at least the discretion. It's not automatic. And then if you haven't looked at subpart G, that was not really part of our negotiations at all. But I would encourage institutions to look, because the department back in January of 17, old administration, inserted a pretty fulsome process for recovery actions. I'm not suggesting it's perfect, but it looks a lot like litigation. I mean, there's motion practice, contemplates cross-examination, it contemplates discovery of a sort, expert witness testimony, all those types of things. So you're talking about when the department looks to recover, a pretty robust recovery process. Now remember, it's not a de novo review. So when you go to that recovery action, it's not as if the ALJ is considering it as a first time, right, a first time brand new case. Instead, what's happening is the decision has already essentially been made by the department that the school was in the wrong. And now the school has to show to a very high standard of review that the department's decision was clearly erroneous. You get a lot of process to try to demonstrate that, but I want to be clear that it's a fairly high standard. So what you would much prefer to do as an institution, if you feel that there is not a valid claim, is to make that point here in the bar adjudication process. And that's why it was so important, and that's why we kept arguing that the institution needs to have a very fulsome involvement here at this stage, because there were a couple of times where it was suggested, well, schools get two bites at the apple, and we immediately said that is not the case. When you are dealing at the recovery action stage, you know, you're trying to overcome a decision that's already been made, and there is a strong presumption that that decision was accurate, right? Okay, reconsideration. So within 45 days of the decision, either party can request reconsideration of an adverse decision based on newly discovered evidence. Again, that's a difference from 2016, where only the borrower had the opportunity to request reconsideration. We added a definition of newly discovered evidence. Also, the department added that they can reopen a claim when evidence becomes available to support a previously denied claim. So the department has sort of preserved some opportunity to reopen claims if relevant evidence becomes available at a later date. It'll be interesting to see exactly how that manifests in the final rule. Several additional points. I made some of these last time in our second webinar. These are really important points. No breach of contract. A couple of times the assertion was made by some of the consumer advocates that breach of contract should be a basis for a bar defense claim. It was in the 2016 rule. It never saw the light of day in this rule. So I would be surprised and disappointed if it showed up in the proposed or final rule. Similarly, while the consumer advocates several times said we think there should be a mechanism for a group claim, and you can read that as class action sort of claim, that was never entertained, right? And there was some discussion around that early on, and you know, we argued that that was not consistent with the statute. Also in a group claim setting, how could you decide whether individual borrowers experienced financial harm, acted reasonably, et cetera, et cetera? That becomes very problematic. But that really did not come to a head because the department, for the most part, did not entertain that concept, and it was never included in any of the drafts. So from an institutional standpoint, these are really important ideas. It's really important that these ideas were left out and not really seriously entertained. Factors impacting partial relief. So we talked a little bit, first of all, the department also, there were some arguments the department was willing to make and stands it was willing to take. One of them was that it had the right to grant partial relief. Interestingly, the consumer advocates pretty regularly argued that partial relief was not appropriate, that if there was a showing and you satisfied all the standards, they should get all of their loans discharged. I will tell you, it was my view that that would be harmful to borrowers, because I believe if the person adjudicating a claim at the department, when you get down to brass tacks, has to make a call between, $80,000 or nothing, and they've got enough evidence from a borrower that they think justifies sort of a $10,000 discharge, then they're probably going to decide against the borrower and go with zero. I mean, that's my view. So I think, frankly, that an all-or-nothing approach has the potential to harm borrowers who may even have legitimate claims. I thought it was very interesting that the consumer advocates were so deliberate on that point, but I presume that they sort of did their analysis and decided that was going to be their policy. The department, for its part, said, we're going to do partial relief. We have to have that flexibility. So then the question becomes, how do you determine how much? I mean, if the borrower has $80,000 in loans, is it 10, 20, 80, right? And so the department floated several concepts that might be used and taken into consideration when deciding, how much to discharge and how much to leave on the table. And those were debated quite a bit. There were several that were added there at the end. It was unclear to me whether the department was seriously entertaining them. But the important thing to note is the department was really viewing this list as a list of benefit. The factors that they were proposing were ways to try to quantify benefit that the borrower received, and that would cut against the discharge of the entire loan, right? One of the things they proposed up front was trying to quantify based on, quote, the value of the education received. I and several other negotiators said we were very uncomfortable with the department, making a call on, quote, the value of education, because that can be so subject to political whim, et cetera, et cetera. But the department tried to then modify that a little bit in a more acceptable way and offered up sort of the value of the educational benefit received to try to get it as sort of a more economic concept. But all of this is to say, even at the end of the conclusion of the negotiations, the feeling was, my feeling was that this was all sort of up in the air. So it'll be interesting to see what comes out of this. Another really important point that was secured by one of the negotiators and the department agreed to was to explicitly state that institutions on provisional approval would still have access to a Subpart G recovery proceeding despite the fact that they were on provisional approval. So there was significant and justifiable concern when the first draft of these regs came out that an institution that was on provisional that the department wouldn't have to go through the Subpart G recovery proceeding with all the due process trappings to recover. And we said, well, that's highly problematic, right? The institution, when you're on provisional, the department could still say boot you out of Title IV in an expedited way. I mean, they have a lot of additional ability to take action. But our point was, if it's a borrower defense claim, whether you're on provisional or not, you're talking about this very specific concept, and it's being, all of this is being negotiated with the understanding that Subpart G is out there, and there's no basis not to give a school, whether on the provisional or not, access to Subpart G, and the department agreed. One point I want to make is, this was a concept that was highlighted and brought to the negotiators by institutions and constituencies that were following the negotiated rulemaking, and I'm not 100% sure it would have been caught by the negotiators without that, maybe. But it just, in my mind, really highlights how important it is that you all as institutions and the constituency keep an eye on these things, because you guys catch stuff. I mean, even if you've got, 8 or 10 really smart advocates at the table, they're not going to catch everything. And so it was a great example of folks pointing something out and us getting to the table and being able to get it included. And I think that the final rule will probably include this concept, because the department did not seem to debate it or take issue with it, and the consumer advocates didn't take issue with it. All right, here's your third secret word. It is McTwist. This third secret word is McTwist with a capital T. So In addition to bar defense, there were these other concepts that were on the table. I know we're at 118, so I'm going to get through these a little more quickly. Financial responsibility being the one that I wanted to hit on most. So again, as in 2016, the department came to the table with this idea of, we need more flags or indicators to understand if institutions are experiencing serious financial distress, right? We don't think that our toolkit is as good as it needs to be. But this time around, the department came to the table with a much smaller list. And as I'll mention in a minute here and talk about importantly, these weren't events that would automatically result in some sort of sanction or surety requirement. It would just result in a reporting requirement. Now, I don't want to, underplay that. I mean, it's still significant that you have to report this stuff to the department, but in some cases, the department likely would already know. And in every case, it is not automatic, and I'll talk about that in a minute here too, that you would have any sort of sanction. The first two rounds, the department led with only 4 items, right? And these are the 4 top boxes. A significant liability from bar defense claims, and they didn't really quantify what that was, but clearly it would have to be significant enough that they had some sort of concern. So remember, this is the one that you wouldn't have to report because the department would know, because they were the ones just making this call and discharging these loans. So what the department is basically saying is, if we discharge a huge amount of loans, significant enough that we think it's material to the institution, that's going to be a reportable event. Now again, this is a little bit of a misnomer because of all the things up on the board here. This is the one that you would not actually have to report because the department's already going to know it, right? But it's what they would call I'm calling a reportable event, what they would call a significant event or occurrence. The second is if a school with a comp score below 1.5 withdrew owner's equity. Now, there are a couple of carve-outs for that. One is if the equity goes to another affiliate. Another is if it was for tax purposes. But, and folks will recognize this has long been something that in certain circumstances you have to report to the feds. SEC sanctions or reporting failures for publicly traded institutions. And then finally, 90-10 rule failure, right? During the last round of negotiating, this last item in red was added, that the institution is required to pay a debt or incurs a liability arising from a final judgment or determination in a judicial or administrative proceeding or settlement related to the making of a direct loan or the provision of educational services. So I tried when I was making my comments at the table to avoid hyperbole, but I referred to this as a disaster, right? And many of us spoke up, and I saw a lot of head nodding, including from private nonprofits and others. And by the way, the department made clear to public institutions that in some of these cases they would still expect a public institution to report, including this last one, right? Which I think surprised the public institutions a little bit. But what we said was, look, first of all, you're disincentivizing institutions to engage in settlement because there's no materiality threshold here, right? So you're telling me I got to report to the Department of Education. And the example I gave was Ohio State, right? When you first read this, you might think, final judgment or determination seems like a fairly high standard. But we're talking about any debt or liability, so that could be $1,000 in an administrative proceeding or settlement, right? So administrative proceeding, I mean, that could be all kinds of different state or federal proceedings, different agencies, whatever, or settlement. Settlement could just be a private negotiation related to the making of direct loan or the provision of educational services. And that's the provision of educational services, again, is extremely broad. Even with the box we put around it, it's extremely broad. So let's say you got Ohio State and they've got 100,000 students or whatever they're up to. Or there are private institutions out there now, particularly when you rope in online, that may have 50, 60, 70, 80,000 students. And I just said to the department, do you have any idea how frequently these folks are engaging in administrative proceedings or settlement discussions and agreeing to settlements or administrative fees or fines that, are totally non-material, $1,000, $1,500. This is administratively unworkable. They're going to be required under this to notify you of all of that, and 99% of it is going to be garbage that you don't need, right? If the whole point here is that this is supposed to be an early warning system for financial instability, you have got to have a materiality threshold that relates to the financial wherewithal of the institution as a whole. And there seemed to be pretty broad agreement to that, except from a couple of the consumer advocates who sort of had this idea that we want any judgment or anything that looks like a bar defense claim, no matter what, to be reported to the department so they can know. But everyone else seemed to sort of agree, and the department seemed to, I think, was nodding their heads and understood that without attaching a materiality threshold to this, this is totally unworkable. And I think there would be significant pushback. This is one, so again, some of my more forceful language was reserved for this particular proposal, and I would strongly encourage institutions to keep an eye out for this if something like this shows up in the proposed rule, and to make sure to provide good comment on if it's not workable, why it's not workable. So, important points. This construct that the department proposed this time around did not contemplate automatic sanctions, all right? Significant liabilities from bar defense or other judgments would prompt a recalculated composite score, right? So in several of those 90-10 SEC sanctions, you would just report it and the department would just think about it. But if you've got actual quantifiable liabilities from a judgment or from a bar defense claim, then the department actually is going to try to recalculate the composite score. But that would be a preliminary finding. They would issue you, they would get back to you with this recalculated composite score, but it would be preliminary. Unclear whether it is official or unofficial. One of the issues that was raised at the table, which was a really good one, is, particularly for a lot of the nonprofits and others that participate in SARA, do online, your ability to participate is tied to your composite score. So if the department suddenly calculates some sort of interim score based on a bar defense liability, does that mean that that's now your new official composite score? And if so, could that theoretically boot you out of SARA eligibility? I mean, and we said, look, that could be highly problematic. You'd have all these students you suddenly would be ineligible for Title IV, et cetera. So those will be some other concepts we'll want to be on the lookout for as this thing gets further refined. But one of the things we really pushed for, and I'm pleased to say the department adopted readily and no one seemed to contest, was the idea that no matter what, whether you're redoing the composite score or whether it's just one of these other reportable events, it's critical that there be an opportunity for the institution to have a dialogue with the department and to demonstrate that whatever that thing was or that event was, it wasn't actually material or germane to the institution's financial wherewithal. And the department agreed with that, and they include language that in every case, among other things, an institution would have an opportunity to, quote, provide information about the conditions or circumstances that precipitated the action or event that demonstrates that the action or event has not or will not have a material adverse effect on the institution. The department, we sort of threw out that concept of material adverse effect, and they bought that. And for those of you who do contract work, I mean, that's a fairly high standard. So, and there was also discussion about whether or not we should really be tying it to a determination by an auditor that would be a materially adverse effect relative to the institution. So this was a really important concept. We weren't going to get away from the idea that the department should be able to request certain information under certain circumstances, but we were very strong about making sure that they didn't result in anything automatic and that schools would have an opportunity to show that they had insurance or other things that would make this go away and wouldn't cause financial stress for the school. For the subcommittee, I know we're getting close to 1:30, but I want to hang in there. I'm pretty close to the end here, so I think about 5 more minutes. The primary issue, there were a couple of really important points that came up with the subcommittee. The first was this issue around the treatment of operating leases as long-term debt and the composite score, and specifically the timing for transition to compliance. So, right now, for those of you who are accountants or sort of hip to this concept, operating leases aren't treated as such, right? If and when they are, which they're going to have to be consistent with the new accounting rules, right? Then that could have an impact on an institution's composite score. So what we said was, look, there are schools that may have just entered into leases and or otherwise have been managing their institutions in such a way that if you flip the switch on this right away, they're going to suddenly have a sub 1.5 composite score, right, or worse. And that's not fair to these schools because they've been managing under their current accounting rules or they signed that lease without knowledge. And what we were really concerned about was smaller, less sophisticated schools because, to be frank, most of the big schools were already aware of this change and sort of been planning accordingly. But we acknowledged that there were going to be schools out there that, for whatever reason, sophistication or just bad luck, that weren't aware, right, and that they shouldn't be penalized when their financial soundness really hasn't changed. And the department and the subcommittee agreed with that and originally proposed a 4-year transition period. We argued for 8 or more and ended up with 6 and thought that was pretty good. So my hope is that folks who are business officers and really will be dealing with this will feel similarly, and also that we will see 6 in the final rule. The other thing that the department threw out more or less on its own volition. This was not coming from any consumer advocates. This was the department. They tried to introduce a concept in the third round, kind of out of nowhere, that would prohibit institutions from using revolving lines of credit to manage their composite scores. There are schools out there that, as a sort of matter of business, will drop cash into their accounts prior to the composite scores being calculated and then pull that cash back out at a later date, which results in a better composite score. And we said, look, whether that's right or wrong, it is something that has been allowed for many years, and you can't just suddenly prohibit institutions from doing it. You got to give them, I mean, first of all, our initial argument was that has not been on the schedule for negotiated rulemaking. It's outside the bounds of what we're discussing here, and the only way you can add it is if everyone at the table agrees to add it. That's just a matter of protocol. But beyond that, we said, look, it's just not fair to do. I mean, this could have real consequences. And by the way, this is for for-profit and nonprofit institutions. We know that there are nonprofit institutions out there that also use this mechanism periodically. And our point was, you know, if you're going to end this, you got to give folks an opportunity to move away from it. In the spirit of compromise, the department deleted that, agreed to delete it to try to get to consensus. But remember, we didn't achieve consensus. I think I already made that point, but if I didn't, let me emphasize that again. I didn't mean to bury the lead. We did not achieve consensus here. So the department has the opportunity to go back and do whatever they want with these proposed rules. Whether they will decide to try to slip this in or not is unclear to me. They removed it to try to get the consensus, but we will have to see what we get. This is one that anyone who has been using a revolving line of credit to manage their composite score will want to be watching for very closely. Okay, and then the final few additional issues, just some comments. There really wasn't a tremendous amount of debate over these remaining issue papers and concepts, but I wanted to highlight some main concepts for you. Under pre-dispute arbitration and class action waivers, look, the department came out of the gates this time around and said, we've met with the Department of Justice. The government has considered this. We do not believe that we have the authority to ban pre-dispute arbitration clauses or class action waivers. We think, you know, the last administration got it wrong, basically. So we didn't have to fight that fight. And the consumer advocates brought up several times that they thought the department did have that authority, and the department did not budge. Instead, they proposed a series of enhanced disclosures. So if you use a pre-dispute arbitration clause or class action waiver, you'd have to tell students about it in entrance counseling and exit counseling and on your website and in all these different places. This was extremely unpopular on all sides. I mean, many folks said, look, just dumping more paper on students is not going to make a difference, right? Interestingly enough, Texas Attorney General and Arizona AG took the position that this still represented the attempted regulation of arbitration agreements and made a very good argument on that front, even though the department disagreed in this instance. And then, you know, there were some of us who said, I mean, I pointed out, look, it was interesting because some of the consumer advocates said, well, why would you not still want to make this disclosure? That seems like bad faith. Wouldn't you want to at least tell students if you're going to use this? And, you know, we pointed out, look, schools that use these arbitration clauses, you know, they put them in giant letters in the enrollment agreement. There is nothing that will lead to an arbitration agreement being defeated more quickly than it not being adequately disclosed. And one of the points I made was, you know, look, it's hard for me to see a reason for doing this. It's more paper you're dumping on students. It's an increased burden on institutions. And all you're going to do is, if there is a bad actor out there who's using an arbitration agreement, by disclosing it, you know, left, right, and center, every chance you get, it's going to make it almost impossible to defeat in court, right? So what possible benefit is all of this rule going to do? I mean, it just seems to be, you know, a bad idea on all fronts. Nonetheless, you know, the department may stick with it. I mean, it was recommended that they just strike the whole thing, and they acknowledge that it seemed very unpopular, but I think they may still move forward. So you may see required increased disclosures around if you use arbitration agreements. Finally, one thing we did fight for is in the event that this all stuck around, that it be very clear that it would only apply to arbitration agreements, you know, in enrollment agreements and things like that. So that if you've got a parking garage, you know, that students use and there's an arbitration clause on the back of the ticket when they enter the arbitrate, you don't have to disclose that to them in entrance counseling, for example. Or if you've got an athletic facility or something like that where they may have to sign something with an arbitration provision. So we were, and the department agreed to that. Closed school discharge, you know, the only, in my view, real material change, there's some conforming stuff, you know, and certainly you'll want to pay attention to all the changes that come along in the proposed rule. But in my mind, the only real material change was they wanted to extend the period from 120 days back to 150 days. I personally, probably louder than anyone else at the table, voiced my general dissatisfaction with the way closed school discharge works. I think they're way out over their skis, and that the process right now is outside of the statutory authority. I also think it does not work effectively for schools or students. And I think the whole thing, frankly, should be thought through, but that was not the purpose of this rulemaking, and they weren't really interested in entertaining my ideas on that front. One thing the department did assert, though, is that they continue to take the position that students that are able to graduate prior to closure are still eligible for a discharge if they withdraw before closure. Again, even if they could have graduated if they stuck around, which in my mind just means that it's impossible for a school to do an orderly wind down. And even if a school does an orderly wind down, it's impossible for it to avoid any exposure. And then on false certification discharge, this is the last one I'm going to talk about. This concerned me greatly, and I want to highlight this for folks, and I want to encourage folks to consider writing in about this in the way of comments if this doesn't get fixed. So the department in the final session came back, and what's interesting is the consumer advocates really weren't so strong on this. It was really just from the department in my view. They wanted to change right now in the false certification discharge rule, there's a reference to ability to benefit, and they basically want to change that to cover false certifications of high school diploma or its equivalent, which is fine, right, in and of itself. But they came up with language that said it is a false certification if an institution certifies a loan for a student who does not have a high school diploma or equivalent. And there was no, I want to be clear what I'm saying here, there was no qualification for whether or not the institution had knowledge or any acknowledged option for an institution to offer as an affirmative defense that the student had misrepresented. So in other words, let me be really clear, because this is an important point in my mind. If a student came to you and you have a form, and I explained to the department, this happens all the time. In most cases, we get the transcript, but you have students who, you know, the school burned down, I don't have my transcript anymore, I was homeschooled. For whatever reason, they don't have access to a diploma, their high school diploma or transcript, but they say, I did complete the equivalent, or high school. So you get them to sign a certification that says that, right? If they sign that, and then you certify the loan, under this definition, that's still a false certification by the school, even though you were relying on their certification and at the time had no knowledge that that was a lie on their part. And the point I kept saying was, you know, it's not a false certification by the school unless the school had knowledge that the student did not have a high school diploma or its equivalent at the time. In the least, the school ought to be able to show you that certification, right, and show you that the student lied to them and that their certification was based upon the student's representation, right? Again, in which case it wasn't a false certification. You know, what's interesting is the department suggested to me in a sidebar that the real concern here was right now in the false certification context, there is no back and forth process in the books, in the regs. That all happens informally. And they didn't want to go down the road of starting to create some sort of what looked like a process. Like, you know, the borrower asserts X and then, you know, the institution can defend itself by saying Y. And I said, look, including a knowledge qualifier here does not create a process. It just makes it clear that it's not a false certification discharge unless the institution knowingly certified the loan when it knew that the person did not have a high school diploma or equivalent. So this is for me, you know, and it may not sound like a big deal, but what I can tell you is in my personal experience, if you end up on the back end in front of an administrative law judge after the department has come in for a program review and said, we think they've done a bunch of false certifications, you know, the ALJ is not going to listen to me saying, well, you know, I had a sidebar at the negotiated rulemaking and I was told that this was, they don't care. You either have a knowledge qualifier in the rule or you don't, right? And if you don't, well, then it's not there. So, and the department sort of suggested to me in the sidebar, well, there's still a back and forth. Practically, that's how it works. But my view is we need institutions, meaning we need a knowledge qualifier here, and that's really what a false certification is anyway. So I'll be advocating for that, and I encourage other schools to keep that in mind and to advocate for it as well. So we're done. Lastly, I do have an integrated timeline here for you that goes all the way through all the major dates. Above the first red line is the prior administration, and below the second red line is future, right? And then, as always, we have some resources, and that's me. So let me try to get to some of the questions here. It doesn't look like there are that many, but I'll see if I can cover them. And appreciate folks sticking around. One of the comments I do routinely get is, actually, sometimes we get the webinar should be longer, and sometimes we get it should be shorter. So we try to do our best just to get to them on time. Okay. Let's see. Okay, can you clarify whether the financial harm element is somewhat exclusive to the misrepresentation standard and not necessarily related to the judgment standard, meaning that arguably a borrower could be successful in a claim with a judgment from a proceeding that did not necessarily find financial harm to the borrower? No, I mean, I think that, that's a great question. I think that the department is still going to require some sort of showing of financial harm. Now, so if you bring a judgment, that's a great question by the person who asked that. My impression is that the department's intention is that there does have to be financial harm. But the other thing I would point out, and this is not something I've talked about here because it wasn't really debated, but this is an important point, and it sort of gets at this. If you do have a judgment in court, and say a student took out $80,000 in loans, and the court and the student brings what's essentially sort of a bar defense style claim, misrepresentation claim, and the court awards the student, $100,000. Then what the department does, students aren't allowed to double dip. So what the department does is they say, if you get a judgment elsewhere, whether it be from a tuition recovery fund or through court or whatever, right, and they pay you some amount, we have a claim to that amount, right, up to the point of your loans. So in other words, if you get $100,000 out of your judgment and then bring a bar defense claim, well, the department may acknowledge your bar defense claim and but they're not going to discharge their loans. They're going to say $80,000 and $100,000 is ours. So it's sort of an offset provision to prevent double dipping, right? And that's really an important point that's not always talked about, but it's important to schools so that you know. And in fact, the department says if you have a situation where they discharge your loan and then subsequently you get that $100,000, you got to pay $80,000 to the department. They can, in other words, reinstate that obligation. But students don't get the double dip. You don't get the money back twice. But that's a really interesting question. This sort of goes in the other direction of what if you got an underlying claim and there was no element of financial harm established? Could the student then use that claim as a basis for a bar defense? I mean, I think they could use it as a basis for a bar defense to bring the claim, but I still think they're going to have to show financial harm to proceed, although it may depend on how the language pans out and exactly where financial harm shows up in the final rule, because it did get moved around a little bit between sessions 1 and session 2 and session 3. So that's a great and really interesting question. Do you think the department will include in the statute of limitations the provision for affirmative defenses up to 10 years versus 5 years? Do you think the department will include in the statute of limitations a provision for affirmative defenses? That's interesting. So one thing the department was sort of thinking about, and I think this question is getting at that, it's coming from someone who was at the negotiations, so it's a good question. At a couple of points, the department was thinking about ways that they might try to get us to consensus. And so they offered up a couple of variations on the statute of limitations. I think in every instance, as a compromise to keep the intentionality standard. Remember, in my view, that was their -- objective. One variation they offered was, well, you'd have a statute of limitations up to 5 years, and then between 5 and 10 years, a borrower could still bring a claim, but only for amounts not yet paid. So in other words, after that 5-year mark, remember when a borrower brings a claim right now, if it's within the statute of limitations, they can not only seek the discharge of loans that haven't yet been repaid, but they can seek to recover stuff they've already paid to the department, right? And so if the department were to discharge all their loans and they'd already paid back $10K, they'd get that $10K back out of Treasury, right? So one of the things the department said was, well, we could try to split this up a little bit, and we could say in years 1 through 5, we'll offer you, the potential for full discharge. And then if you bring a claim after year 5, all you have the ability to potentially discharge is amounts you haven't yet paid. So, something else the department could do, interestingly enough, is they could try to do sort of a hybrid approach with regard to those affirmative defenses. And they could say, in years 1 through 5, you can bring a claim. In years 5 through 10, you can bring a claim, but the institution can try to defeat that claim with certain affirmative defenses. My concern is, I think philosophically that doesn't make as much sense to me. I mean, if an institution's got an affirmative defense, they've got an affirmative defense, and it really shouldn't apply. But frankly, that prior scenario of only allowing a borrower access to, funds not yet repaid after a certain period really is kind of arbitrary, right? I mean, that's just the way the department's trying to limit the risk associated in years 5 through 10. So, yeah, it's an interesting question, and I think, it's something the department can consider. I think more likely, though, if we see affirmative defenses pop back up, if you're talking about the borrower defenses that I mentioned earlier, I think you're going to see those in subpart G. And I don't know that they'll be tied to the statute of limitations in any particular way. I think it'll just be if the department has discharged a loan and they're now going to try to recover from the school, they're going to say, these are certain things that a school might produce in the way of evidence that would be a basis for us not to proceed with the recovery action. Let's see. Is there no appeal process once the department issues their decision per the draft claim process slide? Yeah. So either the school or the borrower, after the department goes through the borrower defense claim process, right, and they decide to discharge their loans, there is an opportunity within so many days for either the school or the student, the borrower, to seek reconsideration based on new evidence, et cetera, right? But there's no appeal process beyond that. The appeal effectively is the recovery proceeding. I mean, that's when typically when you have an appeal, it's not a de novo review. So typically what would happen in an appeal proceeding is there would have been an initial determination, and then there's a standard for the review. So if you've been involved in an accreditation process or in other areas, right, or administrative law settings, you would have to show that the decision by the initial tribunal was, like, for example, clearly erroneous is a review standard, right? Well, essentially here, the recovery proceeding functions in essence as that appeal, right? So the department discharges the loan to the borrower. You have an opportunity to seek reconsideration. If you don't seek reconsideration, then the department has the opportunity to try to recover from the institution. And that recovery proceeding is in front of an ALJ. It's carried out in connection with subpart G of the regs, and you use a review standard. So the institution would have an opportunity to demonstrate through a pretty fulsome process that the decision made at the initial level was clearly erroneous, right? So that sort of is the appeal. Okay. Oh, okay. That's the last question. So thanks so much to everybody for tuning in. Really appreciate your time. And if you have questions, give us a holler. We're always happy to chat. We will probably be doing a series after the proposed rules come out to talk a little bit about those. And again, if you're thinking about after the proposed rules come out, comments, and you need some help drafting those or thinking through them, obviously that's something we would be delighted to assist you with. Have a great rest of your week, and look forward to chatting with you again in the future.